Hello everyone, myself Priya Mohindra. I am from School of Management and Commerce. Today's topic of discussion is procedure for incorporation of company. As we all know, company is an association of person where two or more members come together for a common motive of earning profit. They collectively do a lawful business with the help of which they try to earn profit. There is no strict or legal meaning of company in the Companies Act 2013. It simply means association of person who get together for a common lawful purpose. A company can be incorporated as well as unincorporated. Incorporated company is the one which gets itself registered under Companies Act 2013 or any other previous law, that is Companies Act 1956. Once a company gets registered itself, it will become a separate legal entity from the members who have constituted it. Moreover, it will have a separate legal entity in the eyes of law. When a company gets registered, it becomes a separate legal entity in the eyes of law from the members constituting it. So, in simple sense, company is just an artificial person which is created by law and having a separate entity with the perpetual succession and a common seal. Once a company is incorporated, it will definitely have a total separate recognition in the eyes of law. One can sue the company and company can also sue the other one according to its own name. So, after understanding the meaning of company, before starting the concept of procedure of incorporation of company, it is must to understand what a company actually is. Now, let's move to the next one, meaning of incorporation of a company. A company is incorporated when it gets registered itself under the company's law. The process which we have to follow for registering a company under the company law or any other previous law, that process is known as incorporation of a company. This process definitely a legal process which is mentioned under the company law 2013 or other previous law. So, incorporation of company refers to a legal process that is used to form a corporate entity, or you can say a company. An incorporated company is a separate legal entity on its own which is recognized by law. Corporation can be identified with terms of incorporation or limited as well. It becomes a corporate entity completely separate from the owners when proper incorporation of company is done under the company law 2013. So, there are four major steps which we have to follow for incorporating a company, which are mentioned under the company law, and these four steps are: first is the promotion, second one is the incorporation of company, third one is raising of capital, and fourth one is commencement of the business. Now, let's start these steps one by one. The first one is promotion of the company. Let's have a quick review of the very first stage of incorporation of company. Promotion is the very first step, or you can say promotion is the initial stage when we have to incorporate a company. Here the idea of starting a business is conceived, a rough idea how a business will be done, which type of business we have to carry on, how the finances are to be arranged, each and everything in rough details will be studied under the heading of promotion. The person who carry out all these activities are known as the promoter of the company. So, it is the very first stage in the formation of company. In this stage, idea of carrying on a business is conceived by a person or a group of persons which are known as promoter of company. They will make a detailed investigation of that business idea, like how much amount of capital is required, is that idea workable or not, how much operating expenses we have to done in that case. Before a company can be formed, there must be some persons who have the intention to start a company or who take the necessary steps to carry that intention into the operation. Such persons are known as promoter of the company. So, promoters are the main person who actually brings the company into existence. They are the one who give birth to the company. various functions they have to perform while doing the promotion stage. And these functions which are performed by promoters are like, firstly they will identify what kind of business opportunities are available in the market, and according to that only they will try to find out what kind of business they can operate. So firstly they will identify the business opportunities, and at the second stage promoter will do a feasibility study. Under feasibility study they will check three things, three kind of feasibilities. First one is the technical feasibility, second one is the financial feasibility, and third one is the economic feasibility. When we talk about technical feasibility, that promoter will check what kind of technology is required for carrying on that kind of business, how that technology is to be acquired, all this to be done under the technical feasibility. And under the second feasibility, that is financial feasibility, here the promoter will check how much amount we have to require to do that business, how that amount is to be arranged, how that capital is to be arranged, all these will be done under the financial feasibility. Last one is the economic feasibility. As we all know, a business is to be operated in the country or in the society. So we have to check whether that business is feasible according to the economy of country or not. And all these to be done by the promoter before starting a business under the heading economic feasibility. After doing the feasibility study of the business or the project, next he will move towards having the name approval. Here he will take the approval of the name of the company. He will decide the name of the company by considering various aspects which are given under the company law. So at here the next step, the next function which he have to perform is name approval of the company. After getting the name approval, appointment of professionals like underwriters and bankers they have to do. Assembling of resources is the main function of promoter, and preparation of necessary documents like memorandum of association, articles of association, prospectus, other agreed documents, payment of fees, etc. before starting a business is to be done. All the basic documents which we require to start a business is to be prepared or collected by the promoter itself. So the very first stage is the promotion. Now let's move to the second stage of the procedure of incorporation of a company or formation of company is incorporation. Here a company will get itself registered with the registrar under the Companies Act 2013 or any other previous law, that is Company Law 1956. Certificate of incorporation is the main birth certificate of a company. Company comes into existence from the date mentioned in that certificate. For doing incorporation or registration with the registrar, following procedure have to be followed. Promoter has to decide the proposed form of company, whether it is a public or a private company. Before registering it with registrar, the promoter must have to decide whether he wants to have a private company or he wants to have a public company. They may form the company with limited liability as well as unlimited liability. They have to decide the name of company agreeable and desirable to all. For example, the name proposed is identical with or closely resembles with the name of existing company is not desirable. Whenever we are trying to have a name of the company, that name must not be assemble or resemble with any other company's name. For getting registration, an application have to be made to the registrar. When this application is made to the registrar, after filling all the documents or after providing all the necessary documents, if registrar gets satisfied, if registrar is satisfied with all the documents submitted by the promoter to him, he will grant a certificate of incorporation. If the registrar is satisfied that all the requirements of Act have been fulfilled, he shall register the company and issue a certificate of incorporation. After getting certificate of incorporation or after doing the stage of incorporation of company, the next stage or next procedure which we have to follow is raising of capital. Definitely we already have conceived the idea, we already had registered our company with the help of registrar under the Companies Act. Now for running a business, what we need sources or funds. How these funds are acquired? The next step will talk about the raising of capital, how that capital is acquired, what are the sources with the help of which that capital can be acquired, and for how much time period we require that amount of capital. So after incorporation of company can raise capital by issuing shares. A private company is not allowed to issue shares to the public. Whenever a company wants to issue the share, they can issue two category of shares. First one is the equity shares and second one is the preference shares. But definitely a private company is not allowed to issue the shares to public. They cannot raise funds from the public by issuing shares to them. Whereas in case of public company, they have full right to issue the shares to the public. But for doing that, public company must have a copy of prospectus filled with the registrar and it will be issued to the public. Public company must file a prospectus copy with the registrar before issuing the shares to the public. Only then they will be able to issue the shares to the public, whether in case of equity shares or in case of preference shares. Those who are intended in purchasing the share capital required to send their application money to the company's banker. There is a specific bank account in which all the money will be collected by the company against the issue of shares, and that is known as company's bank account. Once a prospectus is issued, the public who wants to subscribe the shares, who want to purchase the shares of company, they can send their application with application money to the company's banker. On the last day fixed for the receipt of application, if a company has received application equal to minimum subscription, the director will start the allotment of shares. Once by the public company minimum subscription, that is 90% of total number of shares issued, is achieved within 120 days of issue of shares. Once that figure is achieved, director will start allotting the shares to the public. A company cannot issue shares until cannot allot the shares until minimum subscription, that is 90% of total issue, is achieved. So after having funds for the company, after having the capital of company, the last stage which we have to do is commencement of business. A private company or a company having no share capital can start its business immediately after the incorporation. As we studied earlier, that we will get certificate of incorporation from the registrar, but a private company or a company having no share capital, they definitely can start their business after having that incorporation certificate. But in case of public company, it becomes mandatory for them to have certificate of commencement. No public cannot start their business no company can start their business unless they get the certificate of commencement of business. But a public company cannot commence business immediately after incorporation. They have to obtain a certificate of commencement from the registrar. For obtaining certificate from registrar, minimum subscription must be achieved. As we studied earlier as well in the last step in raising of capital, that a public company must have the minimum subscription for allotting the share. Once minimum subscription is achieved, they can start allotting the shares, and after that they will have a certificate of commencement of business from the registrar. After doing all these activities, they can start the business. So this is the procedure, or you can say these are the following steps which a company have to follow while incorporation of the company. कोई भी कंपनी हो, किसी भी तरीके की कंपनी हो, we have to follow these following steps. Thank you.